Ladies and gentlemen of the jury, at the close of arguments of counsel, it is the duty of the judge to instruct you upon the principles of law that should govern you in your consideration of the evidence and in reaching your verdict. It is your duty as members of the jury to take the law as it is given in the judge's instructions and to apply that law to the facts in the case which are properly proven by the evidence, and in that way arrive at your verdict. It is your duty to exclude from consideration everything except the evidence received in this trial, and the law as given to you by these instructions, and then from these alone, guided by sound reason and judgment, reach your verdict. The law presumes every person charged with the commission of an offense to be innocent. This presumption attends the defendant throughout the trial and prevails at his guilt beyond a reasonable doubt. The defendant is not required to prove his innocence. The burden of proving the defendant guilty of every element of the crime charged is upon the state. Before you can return a verdict of guilty, the state must prove to your satisfaction beyond a reasonable doubt that the defendant is guilty. If you are to reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you should do so and find him not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and reasonable and rational consideration of the evidence or want of evidence. It means such a doubt as would cause a man of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is merely fanciful or speculative, such as a skeptical mind might suggest. A doubt which ignores a reasonable interpretation of the evidence or which arises merely from sympathy or from fear to return a verdict of guilty is not a reasonable doubt. A reasonable doubt is not merely a doubt such as may be conjured up in the mind of one desiring to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth and give the defendant the benefit of a reasonable doubt if it arise in your minds after you have carefully considered all the evidence in the case. The information in this case charges that on the 17th day of May 1976, the defendant, James William Jones, being then and there under the influence of an alcoholic beverage, did feloniously, by operating a motor vehicle in a negligent manner, cause the death of Mary Smith, a human being, said offense occurring in the city and county of Milwaukee, state of Wisconsin, contrary to the statutes and against the peace and dignity of the state of Wisconsin. Homicide by intoxicated user of vehicle, as defined in the criminal code of this state, is committed by one who causes the death of another by negligent operation or handling of a vehicle while under the influence of an intoxicant. Before the defendant may be found guilty of that charge, the state must prove by evidence which satisfies you beyond a reasonable doubt that there were present the following four elements of this offense. First, that Mary Smith met her death because of injuries sustained in a collision involving a vehicle being operated by the defendant. Second, that at the time of the collision, the defendant was under the influence of an intoxicant. Third, that at the time of the collision, the defendant was operating his vehicle in a negligent manner. Fourth, that such negligence on the part of the defendant was a cause of the death of the said Mary Smith. The second element of this offense requires that the defendant was under the influence of an intoxicant. You are instructed that the driver of a motor vehicle is under the influence of an intoxicant when his ability to operate a motor vehicle is materially impaired because of his consumption of an alcoholic beverage, a narcotic drug, or other intoxicating substance. Evidence has been received that within 2 hours after defendant's alleged operation of a vehicle, a sample of his breath was taken, and evidence of an analysis of such breath sample has also been received. The law provides that the presence of 0.15 of 1% or more by weight of alcohol in a person's blood, when coupled with corroborating physical evidence, is a sufficient basis for finding that a person was under the influence of an intoxicant. The third element of this offense requires that the defendant was operating the motor vehicle in a negligent manner. You are instructed that a person is operating a motor vehicle
That's good.